In 16 days, on the 25th, the Supreme Court will hear another case involving presidential power, presidential immunity. This is not the first time, but I think after the ones we've done too, this is like the fourth time that the U.S. Supreme Court will hear a case involving President Trump and immunity. This time, it's criminal immunity, and it's involving both official acts as president and unofficial acts. And this is a quote we've pulled. This is from page 9 of Jack Smith's brief that we find where the federal government is looking to expand this ability to bring lawsuits against former presidents to a point where, we said, remember, in the lower court in D.C., we were concerned about that appeals court basically saying that presidents lose all of their immunity the moment they're no longer president. And you think, wow, so you have this, you have CIA black ops that are not even, written down on paper, where we know that there are technically laws being violated. I mean, that's why they are off book, but yet they're funded by the government. Everybody knows these exist. Could you prosecute if you found out one of those that went wrong? Like you mistargeted al-Zawahiri and you killed an American citizen and a minor, which Barack Obama did. Could he then be prosecuted? I mean, I don't believe so. I don't think that's what the authors of our Constitution, I don't think that the authors of these congressional laws would think that kind of law should be applying to a president of the United States during a valid act that may have gone wrong. Because you can imagine as president how many valid decisions you make that are tough that don't always turn out right. It doesn't mean they're always policy decisions that you would support or that you like, but they are still policy decisions. And the idea is, can you actually prosecute them for that? So what Jack Smith is asking here is, quote, a former president is subject to federal criminal prosecution for personal and official acts that violate valid criminal laws. Now, if you don't put any limit there, I mean, where is the limit? I mean, the president declaring war, then war kills people. War kills civilians. There are civilian casualties. Killing people who aren't legitimate combatants could be a crime. What about suspending habeas corpus in the United States if you're Abraham Lincoln? Can he be prosecuted? I mean, think about all of these different situations. Declaring martial law, post 9/11, putting the military on the streets in Washington, D.C. and New York. I don't believe there was any act of Congress to do that. I believe it was just done. Later, there may have been an act of Congress. These are decisions the president has to make quickly that, again, may again violate some law, but yet we kind of like let those laws be superseded by the need by only one person in the United States, and that's the president of the United States. That would still cover if you're doing anything personal that's criminal or unofficial that's criminal. But you know what their problem is here is ensuring that an election was valid, even though they believe Donald Trump was crazy for saying it wasn't. Ensuring an election was valid would fall under an official act of the president, Logan. And that's why they have to be so broad that basically you could start prosecuting presidents for decisions and policy you don't like if it didn't go perfectly. These are interesting questions the Supreme Court usually doesn't like. For instance, how far does presidential immunity go? They had to answer that a few times under President Trump. This time they're having to figure it out as a former president. Now, the interesting thing is that the former president who might be president again are they subject to federal criminal prosecution for both personal acts that violate criminal laws and official acts that violate criminal laws? And that is a main question. Jack Smith and Department of Justice are asserting that the president can, and a former president can be prosecuted for these official acts that violate valid criminal laws. I want to go to Harry Hutchinson on this because, Harry, the question is, there's nothing limiting that. There's not a discussion about all the things we just went through of decisions presidents have to make that, again, whether it's a CIA operations that may violate international laws, U.S. laws, targeted assassinations, we know that were carried out by Soleimani. Sometimes those violate laws that are on various international laws as well, maybe even U.S. laws. I mean, it's not like the U.S. I'm not saying the president every day is violating laws, but certainly through their official acts, there is one person in the United States that is able to take actions kind of outside of the regular legal system, and that happens to be the President of the United States, who can send troops to war for 90 days, without getting congressional authorization.
You're absolutely correct. So Jack Smith offers an extraordinarily broad claim denying presidential immunity. Essentially, Jack Smith wants to criminalize and offer up for prosecution virtually any act entered into by the President of the United States. So, for instance, in 2011, President Obama issued a drone policy which led to the killing of an American citizen, Anwar al-Awlaki, on October the 14th, 2011. That was a drone strike, and arguably, if Jack Smith is correct, we could now prosecute President Obama. Similarly, President Obama ordered the extrajudicial killing of Osama bin Laden. I am sure that some international law was breached by that activity, although it was supported, I would submit, by the majority of American people. So there has to be, in my judgment, some limitation placed on Jack Smith's very broad theory. Presidents are entitled to engage in acts that are designed to ensure the effective functioning of the executive branch. Jack Smith wants to take that right away, and I think the Supreme Court should deny it.
It's interesting. A lot of comments are going through, and a lot of them are about Jack Smith's power in this.
Yep.
And how does someone essentially get this much power in this kind of position?
Well, I mean, he's a special prosecutor, so he doesn't get to make this decision. He's asking the court to decide. So he's been at the Department of Justice before, heads of divisions before. He's also been at the International Criminal Court before as a special prosecutor there, investigating war crimes. He's the one who brought the charges against Bob McDonnell. He's a lifer when it comes to political cases. So this is kind of like in his wheelhouse. That doesn't mean, though, he's not the judge. He's also not the jury. So he doesn't get to decide. He's putting the case forward. He's putting the argument forward. It's not giving him the power to say the president can be prosecuted for official acts that violate criminal law if they're the former president. He's saying they should be, and he's putting that forward to the U.S. Supreme Court, who can ultimately make a decision on that. So people like Jack Smith get appointed to these positions as special counsel. They are usually special counsels are individuals like Mueller, who served at high levels of the Department of Justice, maybe in private practice now or are no longer with the federal government, who then get recruited to take on these special cases. I think it's a waste. I think we spend tons of money on the Department of Justice. They got plenty of attorneys, and these attorneys shouldn't have a problem putting aside their conflicts of interest with the administration. They should be able to look at these cases and without having to have a special counsel that has to have its own budget. But this was kind of a intermediate play. We used to have an independent counsel, Logan, which was set up by Congress. That was what Ken Starr was. That has been no longer approved, so you don't have those anymore. And they would kind of run around and be able to have this subpoena power that was outside of the presidential appointment system. Jack Smith, for all intents and purposes, even as a special counsel, could be fired by the Attorney General, could be fired by the President of the United States. They are not, though they're supposed to have more independence. In truth, they aren't. I mean, Harry, there's a way Jack Smith I think the reason they're having to argue this is because the baseline of what the charges on President Trump were that the election was invalid, and the President of the United States certainly has a valid interest. So it would be an official act that was valid to some extent in ensuring that the election was fair, that the election laws were followed. I mean, certainly a president has that. When does it cross over a line to, is it some criminal act to question that? That, to me, is a very difficult line for the Supreme Court to draw.
I think that is precisely correct, and I think the line is arguably fact-specific. And so the appropriate remedy in this case, I think, is for the Supreme Court to send the case back to the trial court for initial adjudication on the issue of immunity, and then allow that particular issue to be litigated up through the appellate courts and perhaps back up to the Supreme Court once we have a factual record on the ground. That's number one. Number two, I would argue that the position that the ACLJ has taken, which is a middle course, is the best approach. In other words, the president should be immunized with respect to official acts designed to further the enforcement of the law. He has an obligation under the Constitution to make sure that the executive branch functions effectively. And so Jack Smith, in my judgment, has taken a very extreme position, and he's taken an extreme position in prior cases, and some might argue that he seeks to usher in what might be called a reign of terror by special counsel prosecutors for political disagreements. And that was the outcome of the Bob McDonnell case. The Supreme Court issued an opinion 9-0 against Jack Smith. So Jack Smith has a distinguished reputation of overreaching. And so I think he's overreaching in this particular case as well.
Yeah, I mean, I think it could be, again, this idea, the Heritage Foundation put up, Harry, and again, we've had a special counsel. We had Mueller, who was also a private citizen and appointed, but they have this idea that, and I'm not sure, again, it's an idea to discuss. I don't think it doesn't stop anything here, and the courts have obviously accepted special counsels, but they say that they don't believe that Garland or the AGs have the powers to appoint these individuals because they are private citizens now, and that's like appointing a private citizen to have this extraordinary criminal law enforcement power under the special counsel statute. I mean, they are usually former DOJ and usually like right out of DOJ, so I don't know if they would just, to get around that, they would just swear them right in. But what do you think?
Well, I think the Heritage Foundation is onto something, that we should limit the appointment of special counsels, and we should subject the appointment to some type of scrutiny beyond the Attorney General's purview if they're going to have special powers. Keep in mind, Jack Smith is prosecuting Trump in Florida, in Washington, D.C., right. And I'm sure if he could find a case, he would be prosecuting Trump in Georgia or Nebraska. And I just think that's too much power in the hands of one individual.
Yeah, and usually, I mean, again, it runs right through the Attorney General's office, and the Deputy Attorney General is usually in charge of kind of running the operation for the special counsel.